Hello, welcome to today's immigration tidbit. Okay, first of all, I need to know who's petitioning whom. Um, you're saying your mom's case is being actively reviewed by USCIS. Does that mean that your mom is petitioning you and that's what's being reviewed, or does it mean that you are petitioning your mom? So I need to know in which direction it goes. Either way, either one of those petitions is not going to take 20 to 25 years. If it is you petitioning your mom, of course, you would have to be a U.S. citizen, and that's an immediate relative petition, which that's just processing time, no visa backlog. So that, if there's qualification, that would take about a year. I suspect, though, that it is your mom petitioning you. So I would need to know if she's a U.S. citizen or a lawful permanent resident. I would need to know if you are over or under 21, single or married. That all changes the preference that the petition is under. Now, there is what's called a writ of mandate to force immigration. The idea is to force them to make a decision. However, if the priority date is years away, there's no need to do that. I mean, why get, for example, an approved I-130 tomorrow when you can't use it for another 10 years? So it doesn't matter if it takes 3, 5 years for them to adjudicate it. So that's why I need to know the preference. Now, if the visa number is current, and if it has taken all these years and they say they are, quote, reviewing the case, which means they're really not doing anything, then it is time to start applying pressure to get it adjudicated, because you can't just wait forever for immigration to decide that they're going to go forward with your case. Now, let me just tell you about the preferences that I think this might be under. If your mom is a U.S. citizen, and if you are single and over 21, then that is first preference. Okay. And it does depend what country you're from as to the backlog. So the visa chart is basically divided into areas of the world, and it starts with everywhere, okay, which that's what you would look at to see if you're not in one of the following countries. Then it divides it out into India, China, Mexico, the Philippines. Those essentially are the four highest immigrating countries on the planet, and they are the highest backlogged countries. So if you're not from one of those countries, then you look at the column that says every other country. Now, if you are married and your mom is a U.S. citizen and she petitions you, that's third preference. Keeping in mind that as we go down, the higher the number, the lower the priority. So first preference gets, more priority than second preference. Second preference gets more priority than third preference, and so on. So if your mom is a lawful permanent resident and you are single over 21, that would be an F2B. So that would be second preference subcategory B. If you are under 21 and single, then that would be 2A. Okay, those are for lawful permanent resident petitioners. And then you have to understand that if you end up getting married during or after the petition, that changes things. So, if your mom's a U.S. citizen and you were under first preference, if you got married, that moves you to third preference. If she's a lawful permanent resident and you get married, you've just ruined the case, because there is no preference for a lawful permanent resident petitioning a son or daughter who's married. Okay, so give me some more facts and I'll be able to let you know more specifically what to do. All right.